Yes, Mr.
Please would your Lordships turn to Supplemental Bundle tab 60, that's in volume 3, page 743.
Yes.
This is a further letter from British Gas in the light of the response that you saw from the senior civil servant. And British Gas essentially pushes back on the reasons why information shouldn't be provided. In particular, in the first paragraph, it says, your invitation to clarify whether the reason we are acting with urgency is due to anticipated legal challenge goes to the heart of the problem, stemming directly from an ongoing failure by the department to provide a full and transparent response. At this stage, the failure by the department to provide us with adequate answers to any of the questions we've asked means it's difficult to determine whether the proposed transaction should be the subject of a legal challenge by way of judicial review. They then go on to set out over leaf, page 744, paragraph 4, a request that they are provided with as a matter of urgency, confirmation that the Secretary of State will not reach a decision until an opportunity for full and proper consultation has taken place, and the Secretary of State will not object to the court hearing scheduled for Friday the 11th of November, setting a date for the energy transfer scheme to be approved, being delayed until such time as the queries have been addressed. So we then see at page 745, paragraph 6, gratitude being expressed for at least the recognition that the government has a subsidy. The proposed transaction will involve a subsidy for the purpose of the TCA. We therefore consider, it says, it's also very important at this point, prior to the scheme being approved, that you explain your analysis of why the proposed subsidy respects the principles set out in the TCA. So this is British Gas engaging with the Secretary of State, saying, we don't understand at the moment how you've justified the subsidy, please let us know. The follow-up from that is then not a further letter from the Secretary of State to British Gas, but a letter from Tower House LLP on behalf of British Gas. That's at tab 62, page 748. The heading of the law firm can be seen at 749, and in a nutshell, it's chased.
So who Tower House?
Tower House LLP were appointed by British Gas to act in relation to this subsidy before.
So what sort of organisation are they?
It's a law firm.
A law firm, sorry.
And we see page 749, paragraph 3. It points out essentially that there hasn't been any substantive reply to the previous correspondence. It then says, please now urgently and without further delay provide full and proper answers to all of the questions set out in the prior letters, the full explanation of the process conducted, confirmation of the terms of the loan, subsidy or other support. So it's still recognising that it's focusing primarily on the concept of a loan, and then confirmation as to how the government considered that the subsidy control principles were met. The response to that, rather oddly, and I should say, by the way, at tab 63, there's an equivalent request filed by Alan Novery on behalf of Scottish Power, who are no longer involved in the litigation. But you'll see that similar requests are made, for example, at page 754. And in particular, at 755, paragraph 9, Alan Novery makes the point that the requests for information were not pursuant to the Freedom of Information Act or the Environmental Information Regulations, and therefore please don't work to the extended timetable that that legislation gives you. The response from the government, rather curiously then, as I've said, tab 64, page 757, confirming receipt of the letter that had been sent by Tower House, noting that E.ON and Scottish Power had been copied into the email, and requesting that no further correspondence from those parties be sent until a reply had been sent to each of them. So that's not exactly taking the matter with the urgency that it is now suggested should have been given by the claimants. This is part of the base legal department, basically saying you keep on asking us for information. The three parties are asking us for information. Please can you all now wait until we provide that information to you. That's in the last line. I would be grateful if the parties could refrain from sending further correspondence on this matter until our response is received.
Rather informal sort of Christian name terms and email, but still, I agree, that's just a presentational matter. You go on.
Now, the next step was British Gas sending a pre-action protocol letter. That's at tab 65, page 759. And at page 760, in terms of the details of the matter being challenged, 6.2 says British Gas also understands, based on extremely limited information provided to date, the Secretary of State has decided to provide government funding to Octopus, which it understands to be circa £1 billion, to allow the proposed transaction to proceed. Now, the evidential basis for that was simply the ongoing press reports, which the Divisional Court had accepted was not a proper basis upon which to plead out a claim. There was no further information that had been given. And we can see, for example, section 8.11 says, as set out below, the funding decision appears to contravene UK subsidy rules as currently enforced through the UK Trade and Cooperation Agreement, as given effect to by section 9. Despite repeated requests for information as to the exact subsidy which has been approved, on what terms and how it said it complies with the relevant subsidy principles in the TCA, these requests have been ignored. So, how can I put that? It would have formed a very speculative basis for a pleading to say it appears that the rules have not been complied with, but I don't know actually what the basis for the decision is. And tellingly, at paragraph 8.31, we see the sorts of articulation of a ground which is at a very high level and is contingent. So 8.31 at page 769 says, on the very limited information which BGT presently has, it contends that the funding decision fails to meet several of the Article 366 principles for the reasons set out. In particular, the loan is not a proportionate measure. Well, we didn't know what the loan was. The loan will likely lead to a distortion in the energy market, and contrary to Article 366, it would appear that the loan will compensate for Octopus's costs in taking on Bulb's customers, which it should have been able to meet without a subsidy. So none of that is categorised with the level of assurance that one would expect from a formalised pleading. Now, the response from the government is at tab 67, page 778. And at paragraph 11, which is at the bottom of page 780, it confirmed that the ETS decision had been set out in a notice dated the 9th of November 2022. It then confirms at the bottom of the page that decision was made on the basis of final advice via officials, via a submission, a ministerial submission on the 4th of November 2022. So that's when matters coalesced sufficiently for the Secretary of State to approve the arrangements. We then see at paragraph 20 yes, I'm sorry. Mr. Peretz reminds me to show you 12, where they refer to two documents that I will refer you to briefly. A detailed subsidy control assessment and an accounting officer assessment were completed and considered when the funding decision was taken. So that refers to two documents which they exhibit and disclose for the first time, which give full and proper details, well, albeit heavily redacted at the time, of the subsidy decision that was in fact taken. Paragraph 20, page 782. The Secretary of State accepted that there were elements of the Bulb ETS which required justification against the principles laid down in Article 366. These are considered in depth in the subsidy control assessment, pages 10 to 17. So that's a recognition that the Secretary of State accepts we are in subsidy territory and is relying on the reasoning in the disclosed document disclosed for the first time. It sets out the basis for the conclusion that it was justifiable. The funding decision is then described at paragraphs 21 and 22. And confirmation of paragraph 25, page 783, that the funding decision in fact was taken on the 28th of October 2022, even though it's the press release on the 29th that announced.
Sorry, where are we?
Paragraph 25, page 783.
Thank you, yeah.
Could we then please pick it up at page 789? Rather extraordinarily, paragraph 44, the Secretary of State refers via the GLD to Article 369, subparagraph 5 of the TCA, and it says it requires an interested party to be provided with information that allows it to assess the application of Article 366 within 28 days. As you note, the period has not even arguably expired and will not expire, even on your calculations, until the 1st of December 2022. So, trying to justify why it's taken so long to provide the details, the Secretary of State says, oh, well, hold on, time hasn't expired for us to provide those details yet. And yet, in the same breath...
Why is that extraordinary?
Well, my Lord, because they're now suggesting we should have been issuing a claim by the 12th of November.
That's I see, yes.
That's what's being suggested.
It's extraordinary compared with the position they're now taking.
Before the Divisional Court. Yes. And it then says, your assertion that it was unlawful to approve the ETS before the expiry of the 28 days is misconceived, and so on. It's not a standstill provision. If we then please look at page 790, paragraphs 50 and 51. There's a reference to the adjourned hearing before my Lord, Mr. Justice Zacaroli, as he then was, on the 29th of November. This is a hearing that's coming up. As the court will be well aware, there was an initial hearing on the 11th of November, which was adjourned, and I'll come to that in a moment. And they then say, despite this window to give you an opportunity to issue proceedings, you waited until the 21st of November 2022 to send a letter before claim. Now that you have this response, we consider it's incumbent on your client to bring any claim it wishes to with the utmost expedition, so there is no further delay. We then see in paragraph 51, in the event that your client does proceed with its proposed claim and seeks by way of interim relief a delay in the commencement of the ETS, our clients consider it appropriate that pursuant to 5.1 of Practice Direction 25A, your client offers an uncapped cross-undertaking as to damages so as to compensate the government and relevant third parties. So not just the government, but relevant third parties as well. Now, page 792, there's a schedule of the disclosure that was finally given, notwithstanding the repeated requests that have been made. And just for your note, a parallel letter is sent to E.ON, and that parallel letter is SB 70, Supplemental Bundle Tab 70, page 803. And it's that letter that formally gives the same response by reference to the British Gas letter to E.ON as well. In fact, the disclosure had been shared with E.ON and Scottish Power before that point. Now, I said I would take you briefly to the two underlying documents. I'm not proposing to go through these documents in detail, but they show you the level of analysis that the Secretary of State was relying upon for the subsidy control decision. The first of these is at tab 44 of this bundle, and this is what the parties have called the SCA, or the Subsidy Control Assessment. Now, I don't have time to go through this in detail, and nor my respectful submission would it be appropriate to go through it line by line. But can I just give you the headlines, which gives you the lay of the land for the document. So starting at the first page, page 618, there's a reference to the rescue subsidy. And that rescue subsidy is what I've referred to as being the funding for the JEAs to maintain in administration Bulb as an energy company supplying customers. Then moves on at 619 to provide a distinction between that rescue subsidy and what is now proposed, which is a restructuring subsidy. And it's recognised that any post-completion subsidy provided after Bulb has prepared a credible restructuring plan could amount to a restructuring subsidy in order to ensure TCA compliance. This new facility is considered against restructuring requirements. So the Secretary of State is acknowledging that restructuring subsidy control principles have to be applied to the funding that is proposed to put in place here. There's a reference in halfway down to a suggestion that the market's appetite for meaningful engagement has been diminished by market conditions, and there was an extended sales timeline which was said to include requests for government support from both Orchid and other M&A participants. I mean, I have to say, I'm afraid I simply don't know who else asked for government support. Certainly, neither of the two appellants before your Lordship's court did do so, and we know that Tulip, whilst it had a structure offered to it, did not do so either. There's then a reference to a number of elements to the post-completion facility, and you'll see over the next 2 pages a detailed analysis of the different elements of the funding, which I've already taken the court to in slightly less detail than this. In terms of the interest rate, which is confidential, that's dealt with if your lordships have the subheading on page 620, one-off adjustment at or around completion. In the immediate bullet point above that, there's a reference to the interest charged on the loan from HMG to Bulb. A percentage is given, which will not be passed on from Bulb to new company Highfield.
Sorry, which para are we on?
It's the last bullet immediately before the heading that begins one-off adjustment at or around completion. So that has a value that's been greyed out.
Yep.
The interest rates in the immediate subparagraph above that. At 621, there are further references to that interest rate and so on. There's a reference to the regulatory change protection. And then 623 talks about the various equity injections that we've looked at. And in the second substantive paragraph on page 623, the note draws as a source of the principles to be applied upon 2 documents. Firstly, the Draft Subsidy Control Act guidance, and secondly, EU state aid law.
Where are we referring to?
The second substantive paragraph, so there's a section by the first whole point that begins the Draft Subsidy Control Act.
On which page?
I'm sorry, 623, my lord.
Oh, 623, sorry, I was reading ahead. Yep, thank you.
623 identifies the 2 sources of guidance for the principles which are to be applied, and it says, as Orchid's bid, that's Octopus's bid, has been proposed following such an open, non-discriminatory and competitive sales process, there is no subsidy to Orchid as the buyer. Their bid was considered by the energy administrators to represent the optimal value for money approach relative to counterfactuals. No alternative bids were received, which requested less public support. Now, in fact, there were no alternative bids received, which requested any form of public support. We then see, please, at page 624, essentially a run through the underlying subsidy control principles. And at page 628, there is an analysis of the extent to which the amount of government funding could be justified by reference, in particular, to the procedure that had been followed. And in row B, which is principle B in the list of principles set out in Article 366, the subsidy has to be proportionate and limited to what is necessary to achieve the objective. If my lords have that, the first bullet point says, the competitive nature of the extensive M&A process demonstrates that the subsidy is proportionate and limited to achieving the SAR policy objective, that there are no viable alternative ways of restructuring, and that the minimum level of funding will be provided to achieve the subsidy. So that conclusion is, we say, based solely on the M&A process, which was designed to elicit a private sale to a new company of the Bulb business. And Mr. Peretz will explain in due course why those are the relevant principles to be applied and why the facts, as I'm proposing to set them out as to the procedure that was in fact followed, do not meet that standard. The rest of this document really goes through the process, but there is repeated reliance on specifically the M&A process. One need only look, for example, at page 633, the first and second bullets. The M&A process demonstrates that in the absence of the subsidy provided, Highflow would not have been in a position to support the relevant costs. Fourth bullet point, the provision of a subsidy for the ring fencing of regulatory liabilities has been made available for the transaction, with Orchid giving their funding calculations which underpin their bid delivered through the competitive process, and so on. So there's repeated references to this process to justify the approach that's been taken. And then at page 637 and onwards, at this particular paper, which is essentially the justification for the subsidy decision that the Secretary of State has reached, deals with the more technical aspects of the TCA regime, specifically whether or not the guarantee is unlimited in nature, whether there's a public emergency as a result of the Russian-Ukraine situation, and so on. And those are all points of detail that my learned friend Mr. Perrott will address the court on. The second document, which doesn't specifically deal with subsidy issues but gives an overall view, is at tab 45, page 642. It's an accounting officer assessment. And given the passage of time, if I could perhaps just take you to the key section, which is at page 657. We see a summary of the subsidy control analysis, which is derived principally from the SCA, which is also being prepared by the government officials to put before the Secretary of State for approval. So those two documents were very important documents when we finally received them, because it showed us, A, what the Secretary of State was in fact proposing to give by way of a public subsidy, and B, his justification in accordance with the subsidy control principles for doing so. Now, faced with that disclosure, I would like to take you briefly to two pleadings that were settled in response. The first is British Gas. We can see that, please, Supplemental Bundle tab 20. So that's volume 2, I think. It's volume 2 of the supplemental bundle. This is the unamended version of the Statement of Facts and Grounds. What's the page number? I'm sorry, page 460. Paragraph 8. There's a bit of a moan about disclosure. Paragraph 9, there's a reference to the disclosure that has just been given, principally the two documents I've referred the court to just now. And then, please, page 462, paragraph 14. It's noted that the pleading is adopted at a very high level. And if one compares this with the amended pleading that was subsequently filed, which my lords will find in the core bundle, tab 10, page 239. This is a red line version of the pleading that otherwise is behind tab 9. But the extent of the red line version, all one needs to do is flick through it.
So again, I'm behind you.
Core bundle tab, volume 1, tab 10, starting at page 239. What counsel instructed at that stage for British Gas did was amend their pleading, and I'm showing my lords the extent of the amendment once disclosure had been given. And so, I mean, it's a somewhat forensic exercise, I apologise for that, but I mean, I'm simply making the point that an awful lot was left to be pleaded in due course following a much more extensive disclosure exercise during the course of the claim itself. Now, though it's fair, and I therefore need to point it out, that the Scottish Power pleading, which I settled at the time on behalf of Scottish Power, was a little more detailed than the British Gas one at the time. I don't mean that in a competitive sense, but it simply is the fact. I don't want it to be taken against me. I personally knew more than British Gas's counsel did at the time. So let me show you that. Supplemental bundle, please. Volume 2, tab 22. Starting at page 487. And it does provide greater particulars of the reason why the subsidy control provisions were not met. But it does so, and please can we look at this specifically, at page 495 to 499. Setting out the details of the funding that's been provided. If the court would be kind enough just to cast an eye over the references in the footnotes, the majority of the references are not to documents that have been provided in the course of the insolvency court proceedings, but they are to the two further documents.
So, sorry, which page are we on?
Page 498, for example, 499,
Yeah.
setting out the details of the subsidy that has been in fact provided. All of that detail, footnotes, references in the two core documents that have only been disclosed to British Gas on the 23rd of November. Now, this pleading was settled, I think, finally on the 28th of November, see page 517, but the relevant pleading of failure to comply with the subsidy control principles was only possible because the full extent of the subsidy was known, and therefore points could be taken. And that pleading starts at page 506. Again, cross-references are to the underlying details of the subsidy, either internally cross-referenced back or to the terms of the SCA, the subsidy control assessment. So certainly in terms of pleading at that stage, we were entirely dependent on those two documents to understand the reasons for the subsidy and the justification that was given for them by the Secretary of State. Coming on then to sufficiency of pleading. The Divisional Court, paragraph 140, essentially suggests that we should have been ready to plead from the 12th of November. That date, as I apprehend it, is selected because there was a hearing before my Lord, Mr. Justice Zacaroli, in the Insolvency Court on the 11th of November, where the hearing was adjourned to enable the parties to finish off trying to understand what had happened, and also my Lord, Mr. Justice Zacaroli, as he then was, agreed claimants should have more time to obtain information and decide whether or not to bring a claim for judicial review. If we look, please, at the transcript of that particular hearing, which is in, again, volume 2 of the supplemental bundle, tab 17, page 431. Internal, page 174, in the course of the ruling that's being given to explain why the matter will be adjourned, my Lord said, I also noted, and Mr. Allison noted, that by agreeing to the long stop date of 31st of December, Octopus have reinforced that they are effectively happy to continue, even though the effective date will be postponed. These points, it seems to me, are powerful ones. I do not concur to the level of urgency in the demand I go ahead with granting an effective date today, but on the contrary, BGT and the other objectors, if they so wish, should be afforded at least some time to consider their position and some time to lodge proceedings in the administrative courts and to seek judicial review. In closing, seeking such interim relief as they consider appropriate does appear to me that the administrative courts, in the first place at least, which should be asked to consider interim relief, taking into account the interests of the wider constituents, and so on. And for these reasons, my Lord adjourned the application. Now, the response from Mr. Fisher, who I think was appearing for the JEAs, unless I've misremembered, was to say, realistically, one now needs a timetable to give us an opportunity. This is internal, page 176. And then tellingly, at the bottom of page 176, he said, we would prefer that, obviously, they put a form of undertaking if they are going to do it, but I can't stand here on behalf of the administrators and immediately identify for you jurisdiction effectively to direct them to do it by a particular date, other than as a condition for participation here in the adjournment or something to that end. Now, we would obviously like as much certainty as possible. We'd like them to be committed to make a decision and have to move those proceedings within the next week or 10 days. And we would like a timetable which, in the light of my Lord's reasons, gives them that 7 to 10 days, and then we have a timetable for evidence and submissions and so on. So at least at that stage, the JEAs were not suggesting that we had to launch a claim on the 12th of November, 11 days before we received the details of the subsidy funding that we needed to be able to plead the case. They were acknowledging that we would have to have disclosure, that we should be getting our act together and bringing a claim within the next week's 10 days. So they don't obviously stand by that contention. It was made by leading counsel on their behalf before my Lord Mr. Justice Zacaroli. But it would lead to a conclusion that 21st of November was the date by which they, in theory, consistently want to say we should have started our case. Now, the suggestion that we had sufficient information by the day after this adjournment hearing to be able to plead the case is, with respect, unreal. You've seen, by reference to the pleadings that were settled at the time, that they were entirely dependent on the disclosure given on the 23rd of November. And might I please ask rhetorically, at least, what is it we knew about the subsidy on the 12th of November that we could have pleaded? And with the greatest respect, the answer is nothing. We knew that there were press reports, which the Divisional Court says are not a basis for pleading. We didn't know what the amount was. We thought it was a loan. We didn't know if it was a commercial loan or not. We didn't know the terms of interest that were payable. We didn't know the terms of the wholesale adjustment mechanism that was being used to deal with hedging issues. If we had pleaded what I've taken my lords to in the pre-action protocol letter, it would have been treated as highly speculative as a form of pleading. And with respect, it's no answer to rely on any detriment to third parties at this stage if we are simply not in a position, because of the recalcitrant approach to disclosure that was adopted by the Secretary of State, if we're not in a position to be able to plead the case, there's not an awful lot we can do. It's like the Oxford City Council case. If we, as we say we are, were entitled to know the details of the subsidy before we could put pen to paper properly, then the fact that we didn't get proper details of the subsidy until the 23rd of November is highly relevant. Now, for the permission hearing, I did prepare two separate chronologies, which I hope would make the point about what we knew and what we didn't know at certain key points. My lords will find this at Core Bundle tab 30, so that's volume 2 of the Core Bundle, tab 30, starting at page 789. There are two separate chronologies I prepared with colour code. This chronology was based on the Divisional Court chronology. It wasn't necessarily agreed in all forms. There are some bits that weren't agreed that were shown in red. That's tab 5 of the Core Bundle, but I'm simply wanting to show you what my respectful submission was known and what wasn't known. So turning at page 789, any entry shaded in grey was material that was not known to either of the claimants until after the claim forms were issued. Material shown in blue was known to the claimants as a result of the participation in the insolvency court procedure before my Lord, Mr. Justice Zacaroli. Yellow was derived from information disclosed on the 23rd of November. And I'm not proposing to do more than flick through it, but if one flicks through it, one sees the very substantial body of material and relevant detail, which wasn't known to my clients at any stage until at the earliest disclosure. See page 797. The accounting officer assessment and the subsidy control assessment, as well as the updated ministerial submission, are the documents that were provided by way of disclosure and which gave us sufficient details to be able to plead the case. There's then some documents shown in blue, which are essentially the underlying mechanics of the transaction, which had been explained to my Lord Justice Zacaroli in his incarnation as a first instance judge, but which in my respect...
You have to go on saying that.
Oh, I'm sorry.
I'm normally banned, as he then was in this court. Well, we all know it's just
usually obvious to everyone, including my Lord. Most of all, thank you for the shortcut. Even then, there are aspects of the disclosure that are material to the final decision making, the final M&A recommendation paper, the report from EY, the letter from the Secretary of State to the Chancellor seeking budgetary clearance and so on, approval from the Chancellor. All of that material was not known to us until after we'd issued the claim. Now, the second chronology, at page 801, has taken out all of the information we didn't know and simply shown what was known. And my lords will see that the presents a very different picture.
Sorry, which page was that?
This is page 801.
Thank you. Sorry to hear that.
Page 801 is clear of any grey entries. I've left in the blue entries and the yellow entries. And the blue entries were available to us from about the 8th of November or so, just after, when Linklaters gave us disclosure of some of the material that's going before the insolvency court. And then page 804 is the disclosure on the 23rd of November. And I would invite you, if you wouldn't mind in due course, just to consider the difference in the extent of the knowledge between the first and the second. And the second chronology was the basis upon which British Gas pleaded its somewhat more skeletal statement of facts and grounds, and Scottish Power pleaded a slightly more detailed. Now, obviously, when counsel draft pleadings, we have to be satisfied that there's a sufficiently arguable case of illegality on the basis of the facts as known to file the claim. It's an ethical obligation. We can't simply plead and hope, and it wouldn't be right for us to do so. More importantly, of course, my clients have to be able to sign the statement of truth. And if all that's known is speculative press reporting that a subsidy of around £1 billion might have been given, then that's a very unsolid basis upon which to bring a claim. And with the greatest due respect, no general counsel at a highly reputable FTSE 100 company could expect to go to his board and ask for sign-off from that FTSE 100 board to plead a speculative case based on press reports at various points, which haven't been confirmed by the government, in circumstances where that party has pressed the government repeatedly for disclosure and been not given the disclosure that it needed to be given. And that sits ill in the mouth of the Secretary of State to then say, you should have known and been able to plead from the 12th of November 2022. It's, with respect, an unreal submission. My next point is about prejudice. And with the greatest respect, the Divisional Court is silent on identifying precisely what the prejudice that is said to have been suffered as a result of a delay from what must be taken to be 7th of November 2023 to 28th of November 2023 as a maximum period of delay. In fact, I think the Divisional Court would have given us the benefit of pleading on the day after the adjournment application before my lord. On any view...
What was the end date?
The end date is the 28th of November when we did in fact issue our claim. So 7, 28, 21 days. I think the Divisional Court have given us until the 12th. Now, in terms of how this played out, there's, with the greatest respect, no way in which a claim issued on the 12th of November could have been heard before the 29th of November 2022, or indeed, which is when the re-adjourned, relisted hearing for ETS approval came before my Lord, or Justice Zacaroli, and nor could it have been dealt with by the 20th of December. And the reason I say that is because we have an unappealed decision of Mr. Justice Swift on the 6th of December 2022 saying that the trial couldn't fairly be held within that time frame. You'll recall that British Gas specifically applied for a directions hearing in the week of the 5th of December. 6th of December, I think, was the first time the court could do it. Those largely present here turned up and argued the toss before Mr. Justice Swift. His conclusion is at tab 25 of the supplemental bundle, which is volume 2 of the supplemental bundle. His conclusion was it couldn't fairly be run.
Page?
That's tab 25, starting please at page 527.
Thank you.
And please could I invite the court to read paragraph 17 through to 23.
So you want us to read those, or is it Tim read them? Yeah? Sorry, were you inviting us to read those?
Yes, please. Yes.
Yeah.
Can I just ask what sort of hearing was contemplated then? Was that an injunction hearing or was it The whole judicial review?
No, none of the claimants applied for interim relief. None sought injunctive relief. That's a point that's taken against us by the JEAs in their respondents notice, and I'll come to it in a moment. But it was simply getting the entire hearing done and dusted by the 20th of December.
So that's a decision as of the 6th of December, that
Yes.
It wouldn't be possible by the 20th. Did
Yes.
you say it follows inexorably that the same decision would have been reached had the application been brought 10 days earlier?
Yes.
Or heard 10 days earlier?
There was no sensible way in which this litigation of this magnitude, in the light of, one needs to bear in mind, I've shown you the two documents that we relied upon to plead the case. Those themselves were heavily redacted at the time, and we didn't have any of the surrounding material. I've got to be careful what I say given my professional obligations, but the pleading was the best we could do on what we had.
I mean, the earlier 10 days wouldn't really have helped much. They wouldn't have helped day for day, because you can only really, on your case, start motoring when you get to the SCA and the AFA.
Devil is very much in the detail. We didn't get the detail until 23rd of November. Imagine we had pleaded something very rough and ready based on press reports on the 12th. Two things would have followed. One, there was a risk of the Secretary of State asking a judge in the admin court for an immediate decision on permission, and it would have looked pretty thin. And two, even if we'd survived that particular hurdle, so that no permission decision was yet taken, we would have had to substantially replead the case once the disclosure came in anyway. So the only actual point that's taken against us in relation to this period of alleged delay is that the consequences of allowing the ETS to go ahead were substantial, which is undoubtedly true. The ETS, once approved, took final form as a result of the approval given by the Insolvency Court. And if, for example, it all had to be unwound, that would have been a significant endeavour, and we recognise that. But of course, that goes to the question of relief, not to the question of permission. And it's entirely possible the court would have given permission and then said, but because things have moved on and because for nobody's fault we are simply where we are, we're not going to unwind it, but we will find another form of relief that does the job, then that would have been fine. That would have been something...
But you say it does the job, I mean, it does a job.
It does a job. It's obviously, I've already made the point, our preferred option is unwinding. If that's not possible because we've moved on, it's too much water under the bridge, the next option is a recovery order in which a level playing field is, albeit with a broad axe, reinstated between the parties so that the benefit of the subsidies is delivered up. And that may be, as my Lord Justice Zacaroli indicated, differential price between the market value of a hedge and what they got. And it may be the differential price between the interest that would have been paid and the interest that was paid, which was zero. So there will be a reckoning that is possible on that analysis, but we're not there yet. That would be a matter for remittal to a divisional court or the administrative court.
Is it realistic to say that the arguments about the difficulty of unpicking really kick in the moment after, or within a very few days after the deal goes through? And they don't get much stronger as the weeks go by.
Well, I think you know that my wish in the divisional court would have been a surrogate competition with a suspended quashing order to enable that to take place. Seeing that that was not practical for whatever reason, then I think essentially the die is cast once the ETS approval decision is made. And it may be that the seeking relief through a quashing order and unwinding was an unrealistic one from that moment. But it's what my clients understandably wanted because they felt that they had received the rough end of a deal, not knowing about very substantial government funding that was suddenly made available to a rival, and which has enabled that rival to double its market share.
Is it realistic to expect anything other than, had there been a recovery order in February, March 2023, that Octopus simply would have collapsed, and therefore it would have inevitably had to be another process? Given the market difficulties and Octopus's own financial standing at that time, is it realistically it could have survived such an order of that
Well,
scale?
the evidence filed by Mr. Jackson on behalf of Octopus was that they're a thoroughly well-resourced company with private equity standing behind them and that they would have been fine. Obviously, if their evidence to the contrary at a relief hearing was, no, this is going to force us to the brink of insolvency, then the court would have had to take that into account. And the court, as I hope my clients would be, are going to be sensible to the real world practical issues of what any aspect of relief does. It's not actually in my client's interest to have chaos in the market. What it does want is a fair level playing field in a highly competitive market. And obviously it would have been open to, for example, the court, if it ordered a recovery order with payment, to make stage payments payable with appropriate interest if necessary. Can I deal, please, with the administrator's respondent's point notice? Essentially, they're saying the issue of delay also needs to be framed by reference to our lack of application for an interim relief. We've got 2 points to make about that. Firstly, it's abundantly clear from the pre-action protocol reply I've shown you that the Secretary of State was expecting any claim for interim relief to be accompanied by not simply cross-undertaking damages for the Secretary of State's loss, but that of third parties as well. And that produces the sort of open-ended liability to loss, which would have been very, very substantial. And for my Lord's note, Mr. Justice Richards in the Gavin and Haringey case, that's Bundle of Authorities 1, tab 14, page 311, paragraph 60, said that the failure to apply for interim relief in that case was entirely understandable because the cross-undertaking in damages and the sums involved would have been very large.
So what case is that?
Crown on the application of Gavin against Haringey London Borough Council.
Okay, thanks.
Mr. Justice Richards.
Yep.
Paragraph 60. And then secondly, with the greatest respect, the suggestion that because we did not apply for interim relief, we had to act with particular expedition is a non sequitur. Assume that an application for interim relief had been made and failed. What would be the consequence on delay? The answer is the delay is either delay or it's not. If we had made an application and it had failed, what would the difference be? If we had made an application and it had succeeded, then the transaction would not have gone ahead, but we still wouldn't have had a trial any sooner than we would have done. And when we lost, I have no doubt that the JEAs and Octopus would have called in the very large cross-undertaking in damages that they would have insisted upon as a condition for interim relief being granted. Another point that's taken against us is that somehow there's a prima facie legality to the decision until it's challenged. Now, in fact, the case that's relied upon for that, which is the Supreme Court decision of Majera per Lord Carnwath, paragraph 29, again for my Lord's note only.
What case?
Majera.
Majera,
Supreme Court.
yes.
Bundle of Authorities 4,
Yeah.
tab 57, page 2260. In fact, Lord Carnwath there recognised that it's only if the unlawful act is either not challenged or the challenge is refused, i.e. permissions refused, that it will necessarily continue to remain in effect. But more significantly, we say this is a dimension where the TCA provides a time limit for bringing a challenge, and there is therefore necessarily a period in which a subsidy granted under the TCA is going to be open to challenge until such time as that period expires. And I'm now going to pass over to, unless my Lords have any further questions for me, I'm going to pass over to Mr. Perez to make those submissions.
Thank you.
My Lord, the division of labour between us, essentially I deal with points under the Trading Cooperation Agreement, and that includes the points on delay. And since we're dealing with delay now, it seems sensible for me to make those points now. And our submission is that, for the reasons given by my learned friend Mr. Beale, the Divisional Court's approach to delay was indefensible on domestic public law grounds. But what I'm going to show is even independently on that, even if you reject what Mr. Beale has to say on that, the Trading Cooperation Agreement provisions show why the Divisional Court's approach to delay was indefensible. Now, the Divisional Court dealt with the Trading Cooperation Agreement point essentially as a coda to their public law analysis, starting at paragraph 154 at page 142 of the court bundle. Now, I'll come to that coda later, because actually where the Divisional Court began to fall off the track in terms of the trading cooperation agreement is actually a bit earlier on, paragraph 145 of the judgment, which is at page 141 of the core bundle, tab 7. And there the Divisional Court says, furthermore, a claimant does not need to have full disclosure in order to launch judicial review proceedings. Indeed, it is usually the grant of permission which is the trigger for the duty of candour and cooperation with the court to arise. Now, whether or not that is strictly correct as a matter of domestic law, it is plainly incorrect.
So, sorry, where were you reading from?
Paragraph 145 at the top of page
145, yes, thank you. Yep.
That is simply not the scheme of the trade and cooperation agreement. And the reason why it is wrong is Article 369, subparagraph 5 of the Trade and Cooperation Agreement, which is at volume 8 of the authorities bundle at page 3692, tab 93. And as your lordships will see, Article 369 is headed transparency, and the paragraph 1 of that article creates an obligation on both parties to have a database. Your lordships may have had incidental reference to what is on the register or the database. Well, this is the register or database now kept under the Subsidy Control Act in the UK, but originally under Article 369(1, a public database of subsidies giving the information set out in paragraph 1. And then over the page, I can skip over paragraph 2, which is about tax measures, but paragraph 3 then also says, in addition to that obligation, the parties shall make subsidy information in accordance with paragraph 4 or 5. Subparagraph 4 deals with the EU, subparagraph 5 is the UK's obligation. And what is said there is the compliance with paragraph 3, the obligation to make subsidy information available, is an obligation to ensure that if an interested party communicates to the granting authority that it may apply for a review by a court or tribunal of the grant of a subsidy by the granting authority or any relevant decision by such a body, and then over the page B, then within 28 days of the request being made in writing, so that's where the 28 days that the government referred to in one of its letters comes from, the granting authority, independent body or authority, shall provide that interested party with the information that allows the interested party to assess the application of the subsidy control principles set out in Article 366, subject to restrictions. And then the tail piece, the information shall be provided to the interested party for the purposes of enabling it to make an informed decision as to whether to make a claim or to understand and properly identify the issues in dispute in the proposed claim. So the purposes of the disclosure is to enable somebody who is interested in bringing a claim first to decide whether to make that claim at all, and B, if they so decide, to understand and properly identify what points to make. The two limbs there.
Well, that's not strictly right, is it? It's whether to make a claim or to understand and properly identify the issues in dispute in the proposed claim.
In the proposed claim.
So both of these are pre-claim decisions.
These are pre-claim decisions. So the purpose of the information provided is to enable the party to decide A, whether to make a claim, and B,
well, in a sense,
how to make it.
Yes, in a sense they're rather tautologous, aren't they? Because you couldn't decide whether to make a claim until you'd identified the issues in dispute.
But it makes absolutely clear that it's not just about whether to make a claim at all, it's also what grounds to advance.
Yes, I see that.
In UK.
Was this specially drafted for the TCA?
I'm not aware of a precedent.
Because precisely this situation wouldn't have arisen under the pre-existing EU regime. Something like it could conceivably arise under WTO, I don't know, but under the EU regime, you would simply presumably para forward.
Yes, and I mean, It wouldn't arise under the WTO regime because, as Mr. Bill has explained, the WTO isn't implemented into domestic law and doesn't have to be. It doesn't create any...
No, but I mean, I take that, but I mean...
this makes...
This structure, what I'm trying to say, is this looks as though it was drafted specially for the TCA.
It is specially for the TCA, yes. It's as Mr. Bill explained, this is essentially to make sure from the EU's point of view that certain aspects, that there are certain procedural protections in place in the UK. I mean, as Mr. Bill has explained, the TCA requires the UK to have a domestic subsidy.
Yeah, I understand
regime,
all that.
And this is part of it.
Yes.
And part of the regime that it creates is one in which there are individual rights to bring action. And this provision is forms part of that, that scheme.
Can I just ask, while we're looking at the actions and the type of actions that you could bring, this was brought as an action for judicial review, but was there any reason why it couldn't have been just brought as a straightforward action against in the Chancery Division, Commercial Court, or King's Bench Division?
Well, I suppose the question would have been an action for what?
Oh, an action that the government's acted in breach of the provisions of the TCA, which is, I mean, what the correspondence was all about. It's only later that you bolt on all these points that wouldn't withstand any analysis at all.
Yes, I mean, the point of the action is to test the lawfulness of a public, what is clearly a public decision, within the scope of judicial
I mean, you can
review.
bring an action against the government to seek a declaration that it's unlawful under the TCA, especially if it's got its own procedural provisions for timetables.
I mean, that may be right, I'm afraid.
Yeah. Well, I mean, but it just seems to have caused an awful lot of problem trying to fit it into a judicial review action.
Well, I mean, the purpose of the provision, apparent from it, it's to make sure from the EU's side of view, because this is an obligation imposed only on the UK, a slightly different obligation on the EU. But from the EU's point of view, it's part of making sure that the UK regime is effective. In making sure that before that people have a right to sufficient information in order to decide whether or not they're in a position
I understand
to challenge.
that, but that's not really what my lord's getting at.
Yes.
The TCA doesn't say anything, quite rightly, because it's about what kind of court proceedings in the UK are appropriate. That's outside its territory, so that's all up to you.
Yes.
Now, I'm concerned just to identify whether it is obvious that all such proceedings invoking rights under the TCA should be by way of judicial review. It doesn't seem to me entirely obvious that they should. Let us just suppose that this was historic, the deal had gone through, you weren't wishing to quash it, but you were wishing to assert it was unlawful because you wanted a recovery remedy, or possibly damages. And months had gone by, but why wouldn't you simply start an ordinary proceeding in the Commercial Court of the Chancery Division?
That may or may not be right, but
Well, I'd quite like to know whether it was right.
I mean, the reason I think
This is not criticising the parties. So when it's, I just want to understand the whole question about delay and delay in the context of CPR 54 and the 1981 Act for judicial review proceedings only applies if these are judicial review proceedings. And it's not unknown, we all know that there are many kinds of proceedings which involve the court having to make a ruling on the lawfulness of the act of a public authority, but which are nevertheless not brought by way of judicial review. And the court can sometimes say it's an abuse, it must be brought by way of judicial review. There's a matter of jurisdiction. You know all this better than I do. It all goes right back to O'Reilly and Macman and Wandsworth and Winder and all that.
I mean, I have to say, I simply do not know what the government's position is, and I don't think they've been asked, to be fair on them, I don't think they've been asked the question as to what their position would have been had we been at the wrong end of permission decisions, saying you do not have permission to bring judicial review, and we had then tried to bring some other form of procedure.
All right, but that's testing it in a way rather adverse to you, because then there would have been all sorts of arguments about two bites of the cherry and so on. I'm just saying, just suppose that there was never been any question of unwinding this deal. But that you decided later, perhaps because of late disclosed information, it doesn't really matter why, you simply decided we're not going to go down that route, we're going to accept this as a fait accompli, and now we're going to sue for a financial remedy arising out of it. It wouldn't seem to me obvious you go by judicial review at all.
Well, I can say, I mean, if the government's position is that there was, and presumably still is, some other door available to us in order to seek...
I'm not interested in the government's position, I'm interested in your position as to what would be open to you and whether...
Yes. Yes, I mean, sorry, my learned junior has pointed out that footnote 1 to Article 373 of the Trade and Cooperation Agreement, that I think we have in front of us.
3699.
Yes, specifically, I'm not sure what I have done with my Trade and Cooperation. No, I'm sure I've got it somewhere. Refers to judicial review.
Yes, but does that mean judicial review
3699.
in the sense of proceedings under CPR 54? I've certainly seen in international instruments the phrase judicial review, and European instruments, is judicial review certainly mean review by a court.
Yeah, well, certainly in an EU law context, provided the EU law would be indifferent to the precise label or precise procedural classification of a route to a remedy, provided there was a route to a remedy. So that's certainly right. I mean,
yes, no, I'm just exploring. Just exploring.
I think rather than my try and make up an answer off the hoof, because
maybe the answer is your junior is right. The judicial review here means judicial review. This is, although it doesn't necessarily say so in terms, that the implication is that TCA actually, unlike most of the rest of it, does provide that the only proceedings should be by way of judicial review.
Yes.
Under CPR 54. Well, fine, if that's really what it means, that's your answer. But I'm not at the moment.
Yeah, and certainly, I mean, when the government, in the end, as it were, implemented the proper domestic legislation, if I put it that way, the obligations that we're talking about, the Subsidy Control Act, then the Subsidy Control Act specifically provides that the challenge to a subsidy control decision is to be brought to the Competition Appeal Tribunal in an application in which the principles of judicial review are to be applied. So that's how the government has chosen to implement.
Well, that suggests, if the government's right about that it doesn't have to be, of course, principles of judicial review, but it doesn't have to be
indeed
in the administrative court under
CPR. That's right. I think the assumption that everybody had, if I put it that way, and certainly I had, and maybe on reflection it wasn't correct, was that in the period we're talking about, as what's loosely called the transitional period, that the way in which you would bring a subsidy control challenge under the Trade and Cooperation would be in England and Wales by judicial review in the administrative court. That would be the mechanism. Now, it may be
that's an interesting point about England and Wales. I can't remember, do they call judicial review in Scotland, or do they call it something different?
I think it's often loosely referred to as judicial review, but I think it's often the technical term is something different. And of course, Northern Ireland it is judicial review.
Yes, as I knew about Northern Ireland, I was just thinking about Scotland.
Yes.
Well, there it is. But think about that. But I mean, it isn't just me being picky. It may be relevant to the approach one ought to take to the question of review, if in the end the relief is a different kind of relief from merely getting primarily getting the quashing of the decision.
Yes. I mean, the point I'm trying to make at this stage is that what you can read, Article 3695 gives a right to information before you decide whether to bring it.
I know, this is all spinning off my Lord Streatham, but
yes.
My Lord Streatham needed to be asked sooner or later.
And my point about that is that in order for that provision to have useful effect, to be a right that is helpful in practice, it must, as a corollary, mean that you can't be in a position where the door is, as it were, slammed in your face before you have got that information or had a reasonable time to consider it. And of course, the effect of what your Lordship has the chronology from my learned friend, the effect of the Divisional Court's decision in this case is precisely that the door of the court was effectively slammed because they say we should have brought proceedings on the 11th or 12th of November, before we got the information that is required under Article 3695, which is on the 23rd or 24th of November. And it's notable that the Divisional Court's judgment essentially ignores Article 369(5). It only mentions it once, which is simply to set out its provisions. That's paragraph 212. And even when referring to significantly perhaps, even when referring to the letters that my learned friend has referred to that make express reference to Article 3695, you wouldn't get that from the Divisional Court judgment. Doesn't seem to think it was relevant that an Article 3695 request was made. And we say that the Divisional Court went wrong precisely because it did not appreciate the implications of Article 3695. Now, in a sense, I could sit down now just on Article 3695, but a lot of the discussion has been about a further provision of the Trading Cooperation Agreement, which is our specific set of provisions about recovery orders, which is in Article 373. So I will now take you to those, and those are at just a few pages on in tab 93. Yeah. In picking it up at page 3699. Probably, as you haven't been taken to this bit of the Trading Cooperation before, if you go back earlier page, Article 372 is the one that requires imposes duties in relation to courts or tribunals. So each party must make sure that the courts or tribunals are competent to review subsidy decisions. So that's the context of this. And then Article 373 makes specific provision about recovery orders. And there you find specific provisions about time limits. And those are to be found at on page 3700, paragraph 3, which determines the specified time period. So the specified period, and then go on to be for the United Kingdom, shall commence on the date on which the article, the information specified in Article 3691, remember that's the database information, was made available on the official website. That, of course, happened towards the end of the year, way after any of the events we're talking about in the context of delay. It shall terminate 1 month later, unless prior to that date the interested parties requested information under Article 3695, and then once the interested parties got that information, there shall be a further 1 month period. Now that specified time period plugs into paragraph 2, which is the obligation on the parties to ensure that provided an interested party has challenged the decision before a court or tribunal within the specified time period, the one we just looked at, then recovery may be ordered.
So these are in fact specific to these time limits to recovery.
To recovery. That is.
So if you were bringing proceedings for unlawfulness seeking a remedy other than recovery, none of this would apply.
Now, the 2 points one would make on that. First is my general point about Article 3695, that it must in general mean that the doors of the court can't slam,
yes,
put it colloquially, before you've had the requested information and a chance to consider it. And that applies whatever, that's a general point. Article 3695 is not limited just to seeking a recovery order. So any type of challenge that you might bring, any type of proceedings you might bring, which relates to the subsidy, to a subsidy decision or other relevant decision associated with subsidy decision. That's in Article 369. So that's true as a general proposition. And interestingly, when it came to the Subsidy Control Act, that was actually, we say, recognised by Parliament, because what Parliament does in the Subsidy Control Control Act is it extends this 1 month limit that you find in Article 373. It applies it generally. And you see that in Section 71 of the Subsidy Control Act, which is at...
Well, sorry, can we just, before we... sorry taking out your course, I just want to understand this more in context. Is this right? Article 373 creates a special remedy in addition to the more general remedies identified at 372.
Yes.
Article 372 says each party shall ensure courts and tribunals are competent, A, to review subsidy decisions.
Yes.
B, to review relevant decisions of associated bodies.
Yeah.
C, impose remedies that are effective in relation to those A or B, including suspension, prohibition, or requirement of action. The award of damages.
Yes.
And the recovery of a subsidy from its beneficiary.
Yes.
So that is really, is that trailing 373?
It is, but of course the final words of C are also important. If and to the extent that the remedies are available under its respective laws. It's a point that it's taken quite heavily by the government in this case, that what Article 371C does not do is, and this is where Article 373 comes in, what it does not do generally is require the United Kingdom to institute a whole new suite of remedies.
Well, yes. Is this then the structure? Forgive me, I'm just having to get this out from scratch. 372 basically says there must be remedies, including from this suite, but only to the extent that they are available under
national law.
373 is different because 373 is compulsory.
Yes, it says.
So just to take the most obvious thing, if damages would not be available in domestic law for an unlawful act, which generally speaking they're not, you don't get those because they are excluded by the if and to the extent in 372(1)(c).
Yes.
But 373 is mandatory.
And you can see that from the footnote.
I know, exactly. Yeah.
Yes.
I see. Thank you. Well, sorry if everyone else got there long ago, but I'm just...
Yeah, absolutely. So there's no controversy about this. This requires the United Kingdom to do something additional to what would normally be on offer in a judicial review proceedings. You have to have this remedy of recovery. And indeed, there are specific provisions in the Subsidy Control Act that set out this remedy. So obviously, it is a new type of remedy in UK public law for this particular class of decisions. So, and when we come back to the point I'm dealing with, which is about time limits, what we say is going on in 373, why does 373 have these provisions about time limits? Well, part of the reason is, and of course, recovery orders are potentially controversial and difficult. They are sometimes very difficult to do. They involve rights of third parties. There will inevitably be a temptation on the parties to an agreement parties who agreed the provision in Article 372 to perhaps make it difficult for parties actually to get recovery orders. And so it was thought necessary to have a particular set of protections in relation to recovery orders that bind the parties to allow a reasonable time, at least a month, plus a month from the provision of information under 369, in which to make a challenge that relates to a recovery order.
And British Gas didn't originally claim recovery, except insofar as it claimed further or other relief as the court considers appropriate. Is that right?
That may be right. British Gas weren't my...
No, I'm sorry. I thought of the E.ON one, shouldn't I? Is it the same may be true about...
It may be true of E.ON. I can't now remember.
I've looked at British Gas. I haven't looked at E.ON.
But
E.ON so did. Well, I'm not sure actually. Anyway, it did.
But I was going to make the point that in any event, though Article 373, the time limits, tie into recovery, actually what our Parliament did when it implemented this in the Subsidy Control Act was it applied that 1 month plus 1 month limit just generally. So if you go to section 71 of the Subsidy Control Act,
this is interesting, but what does it prove?
Well, what it may well show is go back to the proposition I started with, which is that actually you can deduce from Article 369(5) that there must be. It simply cannot be the case that a limitation period can expire before you have had the specified information to which you have a right for the purpose of deciding whether to bring proceedings and precisely what grounds to advance, that the door should close before you have had that information to which you have a right, pre-action, and then a reasonable opportunity to think about it.
Can I just ask how this interplays with the domestic arguments we've heard already? Because the finding of the Divisional Court at 151 and 152 was that your clients had sufficient information to bring the claim. Now, that's either right or wrong on the domestic analysis. If it's right, are you saying that if a party does have sufficient information to bring a claim, nevertheless, it cannot be prejudiced or it can't be barred on the grounds of lack of promptness and delay because of the provision of the TCA?
Well, the Divisional Court, of course, accepts and indeed makes the point that had we brought proceedings earlier than the provision of the subsidy control assessment on the 23rd of November, we would have then later had to amend. I mean, essentially it says, well, that's what might be what you had to do. But implicitly, that is a recognition that the information we had at that stage was not sufficient in order to decide. Remember, it's both whether to bring proceedings and, to paraphrase, what grounds to advance.
Well, that's suggesting their decision in 151 and 152 was wrong.
Yeah,
but I'm testing this against the proposition that decision was right.
Well, I think the point I'm making is that when you go to perhaps it's helpful to have 369, the text of 369 in front of us. What it is a right to it's to have information that allows the interested party to assess the application of the principles. You've got to have information to assess the application of the principles. Now that must mean, at the very least, an explanation of what the reasoning was of the Secretary of State applying the principles. Now, I think as Mr. Beale has shown, as of the 11th or 12th of November, we did not have that information. We had no information about what the Secretary of State, how the Secretary of State had approached the Article 366 principles. What was the objective, Principle A? How was he satisfied that the subsidy was the minimum subsidy necessary, which I think is Principle E? That we simply had nothing. Somebody will correct me if I'm wrong, but as Mr. Beale went through the correspondence, there was really nothing that came from the department before we got the subsidy control assessment on the 23rd and 24th of November that explained at all, let alone explained in any detail, what the Secretary of State's view was as to why the conditions in Article 366 were satisfied. I mean, there's no mention of Article 366 at all in any of the correspondence. So, because there is in the subsidy control assessment, which is why the subsidy control assessment is at least arguably, and I'm assuming the purpose of the argument, that is the point at which we got a sufficient response to our 3695 request. So there really is no basis for saying that any earlier point we had information that enabled us to assess the application of the principles, because we knew nothing, really nothing, about how the principles were applied. Now, it may be that what the Divisional Court was making a domestic law point, that even though we weren't able to assess, we could sort of guess, and of course we could amend later. But whatever the merits of that in domestic law terms, and I of course adopt what Mr. Beale says, that it doesn't have merit in domestic law terms, it is hopeless as a justification under 3695.
Because it's not information.
Because it's not information that enables us to assess the subsidy. We're simply not told anything that how the Secretary of State assessed the subsidy until the 23rd of November. Article 3, as I say, I mean, in a nutshell, Article 366 is not even mentioned.
Can I just feed in slightly to an earlier point? I've just been looking at section 31(6) of the 1981 Act, which is obviously concerned with an application for judicial review. Application for judicial review is defined in 31(1). By reference to the kind of relief sought. Mandatory prohibiting or quashing order, old-fashioned prerogative orders, declaration or injunction B, and then C, rather specific one. And those have to be made in accordance with CPR 54, especially by procedure to be known as application for judicial review. Just suppose, in the hypothesis I put to you a few minutes ago, you were only going for a recovery. It wouldn't be an application for judicial review. It wouldn't even be properly brought under CPR 54.
I suppose that would raise the question of where one would bring it.
Well, the High Court has a general jurisdiction.
Into High Court General's jurisdiction.
I mean, you might, if you wanted to bring it by way of judicial review, you might put in a claim for a declaration, and then you'd have a hook. But frankly, you wouldn't need a declaration. It's true. As part of the clause of action for recovery, there would have to be a finding that the decision had been unlawful. If you didn't claim a declaration, it wouldn't be under. This may all sound very arcane, and clearly that's not the situation we're in here, but it does just tease out what the relationship, it helps to think about what the relationship is between a claim for recovery, which may well be all you're really left with now, has always been on the cards as a fallback, as all the only substantial remedy you might get, and the application and the time limits question.
Yes, I mean,
think about it.
I mean, I think just as off, I mean, there would then have been a question about whether what the time limits would have been for such an application.
6 years.
But I mean, what matters from my perspective is if the government had tried to argue, had we taken that course, and to be frank, certainly from my perspective, I don't know about my learned friends, we never contemplated that. But had we done it, and had the government then said, you're too late.
Of course, it's not directly applicable to the situation. That's not my point. My point simply
is more general one.
It is testing the extent to which 373 is really a different sort of, creates a different sort of creature with its own self-contained regime. That's really the point I'm getting at.
Yes.
Okay.
Now, the only, I think, point remaining for me to deal with, under conscious of the time, is the point made heavily by the JEAs about Section 72, subsection 8 of the Subsidy Control Act. And essentially what their point is that shows that Parliament, when it came to implement the obligations in this chapter of the Trading Corporation Agreement, provided the CAT with a general jurisdiction to refuse relief on the basis of refuse a recovery order on the basis of undue delay. And they say that shows that Parliament took the view that it was possible to refuse recovery on the basis of undue delay, even in a case where the time limits, which are the 1 month plus 1 month for bringing the proceedings in the CAT, are respected. So, of course, part of our answer to that, or first response to that, is to say, well, Parliament might have got it wrong. It's not that even if Parliament did take that view, then that does not bind this court as an interpretation of the Trading Corporation Act. But in any event, there is a perfectly coherent explanation of why Section 72(8) is there in the Subsidy Control Act, which does not involve any contradiction, if I can put it that way, between that provision and the proposition I'm advancing, that once a claim is brought within the 1 month from the receipt of information time limit, then the doors of the court cannot be slammed in its face. And if we go to the Subsidy Control Act, which is at tab 94, or certain sections of it are in tab 94, your lordships will see.
Can you give me the page?
Yes, page starts. The extracts start at 3.7.10.
Thank you.
And the provision the JEAs rely on, section 72, subsection 8, is at 3742. So 3742, you will see that the CAT may refuse to grant relief if it considers that there has been undue delay in making the application. That's provision 6, the reference to undue delay.
And there's no
And of course, an application will only be made in the CAT, can only be before the CAT, if the time limits set out in section 71 have been met. And those time limits are on page 3738. And you see that how section 71 works. Section 71 time limits for applications and inserts a provision into the CAT rules, a new rule 98A. And then new rule 98A1, A2 says that, well, for paragraph 1 is it's got to be before the end of 1 month, beginning with the relevant date. And then 2 defines the relevant date in relation to a subsidy decision is in a case where a pre-action information request is made, and that is section 70, if you scroll down to 4A, that a pre-action information request means a request for information under section 76, and section 76 is the domestic implementation of 3695. It confers the right to information on a person contemplating bringing proceedings for the purpose of bringing proceedings. That's section 76. So in a case where that has been made, then within 1 month of the transparency date, the date on which the notice under paragraph 8 is given, and the subparagraph 8 is the response to that notice. So this is essentially implementing the time limit that you will remember from Article 373, the 1 month plus 1 month time limit. And that applies generally to all proceedings in the CAT. So it may be asked, how does the provision on undue delay sit with that time limit? Surely, the JEAs effectively ask, the undue delay provision must, since you're only in the CAT if you've met the time limit, surely it must be applied to cases where that 1 month plus 1 month has been complied with, but the CAT says nonetheless there's undue delay. And therefore, the JEAs say that shows that Parliament took the view that the TCA is compatible with a situation where relief is refused, even though the 1 month plus 1 month time limit has been respected. Now, we say that is simply incorrect as a deduction from the Subsidy Control Act. And the reason why it's incorrect as a deduction from the Subsidy Control Act is that that 1 month plus 1 month time limit is not always applicable. There are cases where it isn't. And the reason why you can see that when you go back to the definition of a relevant date. The relevant date, which is the one that starts the time limit running, is either the one we've looked at, A, or B, which is irrelevant, or in case C, when the transparency date. What is the transparency date? It's the date on which the subsidy is put on the register. You see, that's the 4B. So the time limit only begins to run when a subsidy detail, when a public authority puts details of the subsidy on the register. Now, there are many cases where, in fact, a challenge is made where there is nothing on the register. And the obvious class of cases where that is the case is where the public authority takes the view that what it's doing is not a subsidy at all. And the challenger says that it is. Of course, if the public authority takes the view that it's not a subsidy at all, for example, because it thinks what it's doing is entirely consistent with the commercial market operator principle, simply behaving as a private body would, then it won't put anything on the register. So the date does not even start. And in fact, as it happens, the only case that the CAT has decided, the case of Durham, which is, I certainly don't need to take a lordship to it, because it references 2023 Cat 50. Case of Durham Company versus Durham Council Limited, that was precisely a case in which the applicant was saying there's a subsidy, but the local authority was saying, oh no, there isn't, there's no subsidy at all. And in fact, the local authority won on that basis. It satisfied the cap that there was no subsidy. Now, in that case, and there's potential for a large class of cases like it, there is the section, the new Rule 98A doesn't provide any time limit at all, because nothing goes on the transparency register. The time limit doesn't even begin. And what the rule in section 72A does is that in those cases, it provides a backstop ability for the CAT to be able to say, because there may be cases where it's very well known to the challenger that a decision has been taken, and it faffed around for a while, did nothing, spent ages, then applies for a recovery order. And that gives the ability to the CAT to say, oh no, you can't have it. You knew about this decision. It may not have been on the register, the time limit may never have started, but you knew about the decision, may have been told about the decision, and then you did nothing for months, and therefore you can't now have this relief. And that's the purpose of section 72.8. You don't need, in making sense of section 72.8 and giving it function and purpose, to assume that Parliament meant it to apply in a case where the 1 month plus 1 month time limit had been satisfied. And particularly, you don't need to make the assumption that Parliament must have intended to allow a time limit to be imposed in a case where a request had been made for information, pre-action information, but that information had not yet been provided. So that's the answer to the JEA's point on section 72.8. And then just a couple of very, very brief footnote points. The JEAs in their skeleton, paragraph 36, suggest that make the point that EU law allows recovery to be refused on the ground of breach of general procedural rules, which they say includes undue delay. Now, the short answer to that point is that there is simply nothing in EU law, and nothing has certainly been shown to us or to the court, to support a claim that delay within the short time periods that we are talking about could ever in EU law be such as to support not making a recovery order. And it's worth noting in that context, again, I don't need you'll take your lordships to it, but the relevant EU procedural regulation governing Commission recovery orders has a limitation period of 10 years. And the two cases cited by the JEAs, one where the courts have considered whether undue delay was a bar to making a recovery order. One of those where the court did accept that there was undue delay of the Commission on the Commission's part involved a period of some 6 years. That's the Acciaierie di Bolzano case cited by the JEAs. And the in 9 years in the Acciaierie di Bolzano case, that's a case where a claim of undue delay was rejected. And the case where it was upheld, which is the French case about the French tax code, was one in which the Commission did accept undue delay, but it was a period of 6 years. So there's nothing to support any sort of contention that EU law recognises as a bar to recovery order as a matter of general principle. A delay of the order of magnitude that we're talking about here, you're talking about years of delay. Of course, there's an issue as to the extent to which EU law is a guide, but I'm JEAs for these purposes are asserting that it is, so that's why I'm dealing with that proposition. And I think that's the only point I need to make at this stage. I can hand back to Mr. Beale to deal with, to move on to ground 2 on standard review.
My Lords, before I do that, 2 very short points of principle. Of follow-up from that. Firstly, British Gas did plead a claim for recovery, my Lord. It's,
sorry, I didn't hear what you said. Sir.
British Gas pleaded a claim for recovery.
Did you? I'm sorry, I
in
didn't
the start. For your notes, Core Bundle, tab 10, page 285, is the track change version. Paragraph C says, appropriate remedies in respect to the decisions, including the recovery from Octopus Bulb, change to Hiveco, of any amounts of unlawful subsidy already received.
Thank you.
Secondly, in answer to my Lord's question about other fora in which this claim could be brought, I was going to take my Lord to section 31.1 of the Senior Courts Act, which says it's only if you're seeking that particular relief that it's treated as a judicial review claim. If we had pleaded simply a claim for recovery, relying on the TCA, it seems to me that could have been brought in the High Court. The time limit set by the TCA arguably would have been applicable. If we had brought a claim for damages, that would have been subject to the 6-year time limit that applies to any actions for damages in tort. So,
well, hang on. I don't want to get into a red herring. What's the basis of any claim for damages here?
It would be a combination of Section 29, breach of statutory duty, and an obligation that you've seen from Article 372 of the TCA to make damages available as a remedy in the event of breach.
I thought when we looked at 372, it's only insofar as it's available as a matter of domestic law.
And a claim for breach of statutory duty.
Oh, I see. All right.
That would be the tort upon which the hook
That would be Section 29, the withdrawal
of the 2020 Act. Yes. So in the same way one has a claim for breach of damages for EU law historically, that was based on a breach of the European Communities Act, coupled as framed as a claim for breach of statutory duty.
Thank you.
That would be the way it would be. I add that procurement challenges frequently go to the Technology and Construction Court under the relevant regulations as civil claims, not judicial review. Those are my 2 short points. Standard review. This is addressed in the judgment at paragraphs 160 to 172 and at 235 to 246. For the court's note, it's covered in our main skeleton, paragraphs 40 to 48, and in our supplemental skeleton at 35 to 41. It's in the Secretary of State skeleton, paragraphs 11 to 28, in Octopus skeleton at 42 to 53, and the JEAs don't cover this particular ground. Now, the Secretary of State has also said in a respondent's notice that the standard applied by the court was wrong and that a rationality overlay should have been introduced to the proportionality assessment. We say with respect that's wrong, for reasons I'll deal with both in parallel. We say it's important to distinguish here 3 separate strands to the claims that are advanced. Firstly, we have a suite of claims where we say effectively that the provisions of the TCA have not been respected by the decision, and Section 29 of the 2020 Act is therefore infringed. In our submission, that involves a hard-edged question of law, and that is confirmed by the Heathrow judgment, a judgment of Lord Justice Green. Secondly, there are allegations of the absence of an open and non-discriminatory and competitive process, which we say is a necessary part of the proportionality assessment and finding that the subsidy granted is the least distorted.
The absence of what process?
Open, non-discriminatory and competitive is the formula that has been used.
Yeah.
And we say that involves an evaluation of the procedure that's been used and its transparency or otherwise. So it's similar to an analysis of the fairness of a procedure, which is something that this court adjudicates upon regularly. So it's equivalent to a procedural fairness challenge in judicial review, for example, albeit that the qualities that are required are necessarily different because it's not the duty, it's the TCA duty to maintain, to respect the...
So that too is a matter for the court.
That's a matter for the court. Thirdly, there are allegations about the proportionality of the subsidy, and we recognised, as we continue to recognise, that any proportionality decision will involve a margin of discretion that's afforded to the decision maker. But the width of that margin is necessarily context specific. And the challenge that we bring here to the Divisional Court's assessment is adopting a wide or very wide margin.
Sorry, these allegations about proportionality, they're still to be judged by the court.
Correct. That's the first point I'm going to make, is that proportionality is still a matter for the court. The court will allow the decision maker a margin of discretion, but it depends on the context of the decision. And so where, in this case, fundamental rights are involved, such as the fundamental right to compete in a market free from government interference, the freedom to carry on a trade, recognised at common law and in Strasbourg jurisprudence, where those sorts of freedoms are in issue, we say that the margin should necessarily be small. And obviously, proportionality is a matter for the court, rather than the rationality of the decision maker.
And that's because it's in Article 366.
Yes.
So it's the hard edge. It's really your first point.
Yes.
Yes, it's not really a third strand, is it? It's a particular subclass within your first point.
Well, proportionality will lead to a legal decision that's either right or wrong as a matter of law. In the course of making that decision, the assessment of the court on proportionality will necessarily bake in a form of margin of discretion for the decision maker.
Well, is that right? I mean, it will obviously involve taking into account the discretion, the judgment made by the primary decision maker.
Yes.
And giving the primary decision maker own assessment, greater or lesser weight, depending on their specialist knowledge and so forth.
Yes.
So, is that sort of like the same thing as saying a margin of discretion, is it?
Well, my submission does not go so far as to say it's for this court to remake the decision of the decision maker. It's a review of the decision maker's decision.
Yes, I see.
And in practice, that has frequently involved not necessarily recognising per se a margin of appreciation or discretion, but simply acknowledging that the court is not the primary decision maker.
Sorry, so it isn't the court's decision then?
No, it is. My Lord, it's the court's decision is to assess whether or not the decision was proportionate or not.
Well, then that is a court's decision.
Well, but the court is not taking the first decision on proportionality. It is reviewing somebody else's proportionality decision.
But we have to be careful about the use of proportionality here, because you started off by saying Article 366 says that a decision must ensure the subsidy is proportionate.
Yes.
Not that the decision is proportionate, the subsidy is proportionate.
I'm sorry, my Lord's right.
You're saying that is a question that the court has to decide.
Yes.
And it's not second-guessing or reviewing the decision of the primary decision maker at all, is it? It's just asking itself whether the subsidy was proportionate.
I think I'm acknowledging that a subsidy issue is not going to get before this court unless somebody has taken a decision one way or the other. In order for there to be a contested decision, one assumes the decision maker has taken the view that it is proportionate. It is for this court to disagree, as it does frequently in human rights cases, and say, you, the primary decision maker, have decided that the removal of this third country national is proportionate. We, the court, disagree, and we find it's disproportionate.
Yeah.
And the appeal is allowed on that basis. Now, the court therefore...
It's disagreed because the court's reached its own decision
of the proportionality of the measure. Yes. So when I say it's not the primary decision maker, the court, it's not remaking the decision from scratch. It's necessarily looking at a decision that has been taken on proportionality, but the court forms its own view as to whether that decision is right or wrong.
Well, I'm not sure this is even right, is this? There are important constitutionality contexts where it's very important the court is never the primary decision maker. And there, if the court decides something's proportionate, it has to send it back to disproportionate. Well, I don't know. That's a slightly different area from here, isn't it? There's simply a test about whether a subsidy is proportionate. Not a question where the Secretary of State, where the legislation says that the Secretary of State must form a view as to whether or not something is proportionate. that is a true case of the Secretary of State being a primary decision maker. But here, there is simply a statutory test. Is it proportionate?
Yes.
And the court is, primary is the right word, but the court is the decision maker, the ultimate decision maker. Isn't that the right analysis?
It is, and Article 366 is an obligation of outcome. The subsidy
Exactly.
that is granted must
Exactly.
be...
So I think all this talk about primary decision makers is a bit of a red herring.
But it may well be I've phrased it indelicately. What I'm trying to avoid walking into is a line of authority that says that the court, even when it's adjudicating on proportionality, it makes its own mind up and it makes its own decision, but there is space for that still being not a de novo calculation, but a review of an existing decision.
That line of authorities may be concerned with different sorts of decisions.
Well, it's helpfully dealt with in the Dalston case.
Is this like a decision like the Dalston case?
Well, Dalston identifies a series of different ways in which a decision...
Well, perhaps we better look at that.
It's in Bundle of Authorities, Bundle 5, tab 68, starting please at 2539.
Now been heard by...
Yes, it's just been heard by the
I've got a
Supreme...
feeling that they didn't... I think I saw or heard that there is no challenge to Lord Justice Singh's summary of
the test.
Of the test.
I'm proceeding on that basis. I'm afraid I didn't get the chance to catch up with the...
No, we don't know. So, yeah, okay. This is the law as it is at present.
Yes. So, it starts at, that's the head note, tells one what one's dealing with, which is essentially the imposition of sanctions. I think there was a seized yacht from a Russian citizen.
Yeah.
And so on. Interference with property was the way it was brought. We look, please, at paragraph 2, 2545, where His Lordship was addressing two separate questions. First, what principles should a first instance court apply when reviewing a decision of the executive on grounds of proportionality under the Human Rights Act? And secondly, what principles should an appellate court apply when reviewing a decision of a lower court in such a case? Neither of these questions are new. So here we have a decision of the executive that a subsidy was proportionate. That's been challenged. But I take my Lord's point that actually, if it's an obligation of outcome, that may be more of a hard-edged legal question. It's either proportionate or not. If it's not proportionate, it's the role of this court to say so. But at the moment, if we approach it as being a review, because it's a judicial review of an executive decision, then we then come on to look at His Lordship's analysis of the principle of proportionality and how it's applied against executive decision makers. It's quite a long section, I'm afraid, but it will save your Lordship's ears and my voice if I invite you to read paragraph 9 through to 21.
And give the short-term writer a break.
I did promise her one.
Well, you've got one de facto now.
I hope that the point I was grappling inexpertly with is encapsulated succinctly at paragraph 19 and 20, essentially. The reference to primary decision maker can be a bit misleading. But, the point we make is this is not a rationality standard. It's for the court to make its own decision. The court decides whether or not the subsidy is proportionate, and it reviews the Secretary of State's decision on that basis. There's then a subsidiary issue of what is the approach one takes to the reasons or the reasoning adopted by the decision maker, where it's appropriate to take into account the fact that the court is not itself the decision maker, somebody else has taken a decision previously. So that's the relationship between the court and the decision maker in that context.
But there may be I hear what you say about that aspect. There may be a second element in all of this, that the principles cover a variety of subject matter. Many of them involve clearly questions of judgment. A, for example, or C, is designed to bring about a change and is conducive to achieving that. Well, that's clearly a matter of opinion and judgment. So take that example. When the court's reviewing the decision of the Secretary of State, is the court saying, well, actually, this is a hard-edged principle, it must be complied with. Therefore, the court has to decide for itself whether the subsidy is conducive to achieving the objective. Which sounds to me rather bizarre, but the court stepping into that sort of arena.
Well, the court still does adjudicate on whether or not there's a legitimate objective pursued by the subsidy. And the court will adjudicate. And what I've classed as hard-edged legal questions will be such as, is it right that there was an emergency situation that caused this subsidy to be required to be granted? Now, that sort of thing is exactly the sort of issue which will be for the court to declare, as Lord Hoffman famously did in the A case, where he said that there wasn't sufficient terrorist threat in this country to justify a conclusion that national security required control orders to be rolled out. So even in areas where there is a high policy ambit, such as is there a public emergency, there may well be a conclusion that the court reaches that there is no basis for saying that there was a public emergency such as to cause the particular subsidy to be required on the facts of this case.
So where the principle involves an exercise of judgment, isn't the court's role simply to determine whether the judgment taken by the decision maker fell within the ambit of reasonable decisions to be made?
My lord, not necessarily, because it depends really how the subsidy control principles are applied. If, for example, there is no legitimate connection between the aim pursued and the subsidy granted, so say the Secretary of State says, well, I'm going to grant this subsidy because I think that a particular market player needs to be boosted for competition purposes. So imagine that the Secretary of State avowedly wants to favour somebody in the market. That is not going to be a legitimate objective.
That would be outlawed on a rationality test, wouldn't it?
Well, it would be, but in my respectful submission, that isn't the right test that comes to be applied through the subsidy control principles. The subsidy control principles, as I've said, they have to be complied with. It's an obligation of outcome, and it's for a court to adjudicate on whether or not the subsidy control principles have been met. The difference is that some of them are broad lines of inquiry where the court will naturally have an inclination not to interfere with an exercise of specialist or executive judgment that is out with the normal decision-making processes of the court. That's simply reflected in the standard rules on margin of discretion. So the less comfortable this court or any court feels about adjudicating on something in relation to the reasons for a decision, the greater the margin of discretion that will be afforded to a decision maker applying those principles. If the principles require, for example, the application of a hard-edged or bright-line legal question, then that is capable of being either wrong or right in law. If not dealing with these principles, but there's a principle in the TCA that is aspirational or geared at something that is not a bright-line legal obligation, then I would absolutely accept that the review necessarily is not going to be compelling a legal outcome. But the wording of 366 is very clear, with a view to ensuring that subsidies are not granted where they could or have or could have an effect on trade, etc., each party shall have in place and maintain an effective system of subsidy control that ensures that the granting of a subsidy respects the following principles. And then you have a series of principles that have to no doubt be analysed and weighed against each other. But some of them do simply require a test to be obtained, one of which is...
Well, are you saying, you may not be agreeing with my lord about particular examples, are you saying that some of the principles are, as you say, hard-edged, let's say the court must make its own decision?
Yes.
Proportionality, which is the one we've been looking at, is one of those, but that some are not.
I mean, the classic one would be, what is the public policy objective that is being sought to be redressed? This court will not be the final arbiter of what the public policy objective is. It's for the second.
Well, I'm not sure that's right, is it? It's just that only requires you to identify a public policy objective, not to say whether it's a good one. The court could certainly not be asked to decide whether it's a good public policy objective. But A doesn't require it to do that, does it?
Well, A would require analysis of whether the public policy objective was to remedy an identified market failure. That's where the hard edge bit would come in. So,
yes.
If, for example, in this case, the Secretary of State had taken the view that the bulb customers imagine there was another insolvency where far fewer customers were involved, but the Secretary of State nonetheless took the view that the same equity objective of making sure that they continued to have access to energy supplies is equally valid when you have a very large number of customers affected. I can see that that could legitimately be the subject of legal debate before a court as to whether or not the specific public policy objective was sufficiently pressing that it was going to be capable of remedying an identified market failure. But the hard-edged bit in my respectful submission would be, you've identified a public policy objective which is to protect the consumer, but the hard-edged bit is, does that constitute an identified market failure worthy of bringing in a public subsidy?
But part of the difficulty may be, I would guess, that pretty well all of these, the ordinary courts would say, oh, we're not good at judging that. But the CAT would say this is the kind of thing we do every day.
And the CMA is doing every day when it makes the advisory opinions available from its specialist advice unit. But we don't have that independent authority at the moment. So the court is flung into the position of being the primary, I'm not going to say that, of being the arbiter of whether or not the principles are met or not. Now, I can understand an objection being taken, and I want to be clear that I'm not being absolutist about this. If, for example, it's a question of 3 subsidy control principles go one way and one goes another, I can see why there's an element of evaluation where the court might be more reticent about not allowing at least some margin of appreciation to the primary decision maker. But there are some things where it's simply...
Well, but you can always deal with that simply by saying, we don't know much about this, but it's clear that the civil servants or the minister looked at this really carefully, and we're going to give great weight to their assessment. That would still be the court being the court making its own decision. It would simply be an evidential point. It would be unsatisfactory if the role of the court was different as regards compliance with some principles and not others.
Well, that's why, with respect, I don't think I'm saying that. So I'm saying whether it's you, whether it's the CAT in due course, the CAT will have to form a view as to whether or not these subsidy control principles have been applied, just as this court has to.
Okay, so you're basically saying all the principles are in principle to be determined by the court, but your knowledge, what you've occasionally slipped into calling a margin of discretion, I think you're now agreeing is better characterised as it is in Dalston, as in the weight in making the court's assessment to be given to the executive decision and the reasoning behind it.
My lord is absolutely right. Yeah, this court will decide whether or not these principles have been complied with.
Yeah.
hard-edged question, but in doing so, you will afford such weight to the decision maker as you consider as appropriate.
Now, under the 2022 Act, is that also the case? I thought there, the decision maker is quite clearly the Secretary of State, and the CAT's role is limited to judicial review.
Well, it's limited to a review of the decision on usual judicial review principles. And if the judicial review principle is this constitutes a hard-edged error of law because you failed to apply the subsidy control principles in a correct fashion, then that's no different from any other non-compliance with law, where I've cited in our skeleton argument the Singh Commissioner of Police decision of the Privy Council, where Lady Black says, in terms, a legal interpretation is a matter for the court. If the court's got it wrong, tough. Sorry, if the decision maker's got it wrong, tough. And it's no answer to say that we thought it was a reasonable interpretation. That's Bundle of Authorities, tab 4, page 42.
You're saying it can be easy to slip from talking about JR principles to thinking that just means Wednesbury or rationality.
Correct.
But JR, in fact, includes other standards of review.
Error of law.
In appropriate cases, depending on what the nature of the issue is.
My Lord, yes. I've slightly skipped ahead to deal with proportionality, but if I may row back for a moment, error of law I think I've covered. It's dealt with in our skeleton. I think it's a relatively, if I may say so, uncontroversial concept that the court tells the executive what the law means, and the executive is meant to abide by it. It was dealt with also, I should say, in the British Sugar case. Again, for your note, that's Bundle of Authorities 5, tab 59, page 2293.
If you want us to go to that.
Well, I'm happy to, my Lord. It's Bundle of Authorities 5, tab 59.
You say you're happy to. I mean, I'm asking whether you want us to.
Well, I'm running short of time.
Well, you must make your choices. I'm not going to go to it unless you take us to it. So I'm not steering you. I just want to know whether I want to get it out.
Can I just tell you what Mr. Justice Foxton did in that case, which is to decide whether or not the tariff quotient that the government had introduced was compliant with the TCA or not. And that's distinguished by the Divisional Court in this case, saying, well, that was to do with whether or not there was a subsidy. But of course, the requirement under Article 366 is that something that is defined as a subsidy, see Article 363, has to comply with the subsidy control principle. So of course there's a threshold question, is it a subsidy or not? But ultimately the prohibition is against the grant of a subsidy so defined that it fails to comply with the subsidy control principles. And we say that 363, 366 direct the court to finding as a matter of law whether or not this particular subsidy complied with those principles or not. So we say it's the same process. Coming then to the issue of open non-discriminatory, again, I hope I can take this relatively shortly. The issue here is whether or not the process that was followed has the necessary qualities to meet the legal test. And we say that the appropriate analogy is with a judgment of my Lord Justice Underhill in the Balajigari case.
It's judgment of the court.
I beg your pardon.
Well,
It's
better not say any more, but there were other members of the court apart from me.
Of course. Bundle of Authorities 4, tab 39, specifically at page 1594, paragraphs 45 to 46. And your Lordship made the point that where the issue is one of fairness of procedure, equality of the procedure that needs to be followed, the courts are eminently well suited to adjudicating on that issue. That was also the approach followed in the National Lottery Commission case. I will turn that up if I may briefly. It's Bundle of Authorities 1, tab 12, page 249. It's a decision of Mr. Justice Richards.
Sorry, can you give me the reference?
It's Bundle of Authorities 1, tab 12, page 249, where the headnote explains there was a procedure put in place for whether or not the National Lottery was to be re-awarded to Camelot or given to the People's Lottery. That led to a bidding round. Neither of the bids found favour at first instance, and then one of the bidders only was allowed to go forward with a bid. If we could turn, please, to page 273. Mr. Justice Richards identified the standard requirement for procedural fairness by reference to the well-known authorities of Lloyd and McMahon and ex parte duty. And then over leaf at the top of page 274, he notes that the court must bear in mind that it's the decision maker, not the court. Parliament is entrusted to make the decision, but nonetheless, fairness requires that a person adversely affected by a decision must have an opportunity to make representations. And Mr. Justice Richards noted it's common ground that it's for the court to decide whether the procedure in this case is unfair, but in reaching that decision, the court should take into account the views of the Commission as to the appropriateness of the procedure. It's also common ground that at the very least considerable caution is required before the court concludes that the breach of procedural fairness has not affected the substantive result. The conclusion that was then reached, paragraph 68 through to 72, was that there had been a breach of the fair procedure requirement in this case. The reasons are set out at paragraph 68 to 72. Please can I invite the court to read those. It's page 277, paragraph 68 to 72. And we say that decision doesn't suggest that a wide margin of appreciation is necessary when deciding a standard question of whether or not the process that's been followed meets certain legal criteria. Because the Divisional Court dealt with it, and because it is part and parcel of the construction of the TCA itself, I would briefly please draw to your attention the observations of the Supreme Court in Lumsden on the EU law principle of proportionality. Mr. Justice Foxton, in the British Sugar case, recognised that the TCA...
Sorry, are you taking us to Lumsden?
Yes, please.
Where is it?
Bundle of Authorities 3, tab 29, starting at page 1166. The precursor was that Mr. Justice Foxton in British Sugar recognised that EU law had fashioned part, at least, of the TCA.
Had what? Sorry, I didn't hear.
Had fashioned part of the TCA.
I
The TCA is a hybrid of EU principles and WTO principles. That's the short one. Lumsden, one of the issues was, is there a requirement to show that a piece of legislation or a decision is manifestly disproportionate or manifestly inappropriate, or is it simply a question of whether or not it's a proportionate measure or not? The answer given by the court, paragraphs 101 to 104, was that it was for the court to determine whether or not the measure was proportionate, full stop. Please could I invite the court to read paragraphs 101 to 104.
Yep.
At 108, we see the test that the Supreme Court then chose to apply, which then applied to the facts. And it's necessary in particular for the court to decide whether the scheme is proportionate as part of its function on deciding on legality. In doing so, it should approach the way in the same way as the Court of Justice would, i.e. no manifest inappropriate test is relevant, see subparagraph 4, and the Court must decide for itself on the basis of the material before it whether or not it's a proportionate measure. In considering the question of necessity, it should be borne in mind that EU law permits member states to exercise a margin of appreciation as to the level of protection afforded to the public interest pursued, because that doesn't necessarily go to the actual conclusion of whether or not a less restrictive measure could and should have been adopted. Daly in the House of Lords is well-known authority for the proposition that heightened standard of review is applicable when the court is assessing proportionality. I don't think I need to trouble the court with that as a proposition. So what do we say here on the standard of review? Well, the answer is that this is a case involving necessarily as a subsidy the transfer of very significant state resources. It's conferring an economic advantage on one actor to the back benefit of that actor over other economic actors.
Well, Howard, what question are you addressing? I thought you've addressed it.
So this is the legal test for subsidy. I'm now seeking to explain to my Lord why that necessarily engages fundamental rights no less or no more than the...
But that would be true whether it was trivial rights or major rights. It's all a question of proportionality.
Yes.
I'm sorry, no, I'm not being difficult. I'm just trying to...
Well, I'm trying to deal in advance with a submission I anticipate my learned friends will make, which is this is proportionality, but it's proportionality other than in a fundamental rights context, and therefore a wide margin of appreciation is relevant, to which the answer is, well, this is a legal test that has to be applied by the court.
Right.
Well, it may be that I'm trying to get my retaliation in early and I don't need to.
No, now I understand. It's up to you again, but I just wasn't sure where we were going.
They also suggest that this is a macroeconomic decision involving questions of high economic or social policy. Again, with the greatest respect, we say that's not right. It's clear that on any view, Parliament has said these subsidy control principles need to be applied in the United Kingdom as part and parcel of our deal with the EU. And therefore, the question is whether or not it is a subsidy or not and whether it's justifiable or not. Secondly, in terms of policy issues, the importance of maintaining a level playing field between the EU and the UK comes very much to the fore. You've got my submission on that already. And thirdly, this isn't simply a question at large for the government as to how it spends taxpayers' money. It's interference in a freely functioning and highly competitive market. The fact that there is a degree of economic analysis doesn't change that. And indeed, the Divisional Court rejected the suggestion that somehow this was a commercial decision. See judgment, paragraph 167, page 144. However, the Divisional Court did go on to explain at 168 that the commercial context was said to be important for the intensity of the review, and with the greatest respect, it was wrong to do so. The court relied upon the decision of this court in the Coventry City Council case. Could I turn that up, please?
Now, can we just think about timing? Your timetable, which I did have, but I seem to have lost, assumed we would rise at 4:15. We don't always rise at 4:15 if there's time pressure, but we don't go on much longer. How long are you proposing to go on longer this afternoon?
I was simply, if I could squeeze this case in,
Yes,
I could squeeze this case in.
I just want to make sure I know where you're going.
That would bring to an end ground 2 and
Yes.
leave us free to start ground 3 afresh tomorrow.
Yep.
So Coventry City Council, it's Bundle of Authorities 3, tab 31, starting at 1185. So that's Bundle of Authorities 3, tab 31,
Page, sorry again.
page 1185.
Thank you.
Essentially, there were a series of commercial arrangements between the council and an entity that owned a stadium, or had rights to a stadium that housed Coventry Football Club, Coventry City Football Club. There were a series of rather convoluted arrangements between the council and the owners of the stadium and or the football club. They're summarised at paragraphs 2 to 9. This was the local council getting involved in a commercial deal in its own right. A new loan, see paragraph 10 at the bottom of top of page 118. A new loan was agreed we see at page 1188, 4 paragraphs down, the new loan from the council to the relevant entity was not at an abnormally low rate because of the company relationship between them, which was a subsisting relationship. It is at a commercial rate, and the loan will be fully secured against the assets of the entity that was the beneficiary. The council's position is secured because it is the landlord of the freehold reversionary interest, so it cannot lose control of the asset should the entity default. Now, at paragraph 11 and 12 is summarised that Mr. Justice Hickenbottom directed himself that a local authority had a wide margin of discretion or judgment when making investment decisions. At paragraph 12, the Court of Appeal recognised that the evaluation of primary facts based on documents would place it in as good a view as the judge in order to work out whether or not the decision was correct or not, and to review his evaluation. Paragraph 15 at page 1190, there was essentially...
But we're now on the different... this bit is about the position of an appellate court reviewing...
Yes.
Is that what you're...
No, I'm not. I'm simply covering that en passant.
I see, okay,
in
yeah.
case it's...
Right, where are we going now?
There was a state aid challenge to the grant of the loan, and one of the issues was whether or not the loan was on terms which were capable of meeting the market economic operator test, or the commercial operator test, as it's now put. The general principles set out at page 1195, a citation from paragraph 79 of some Commission guidance, identifying the market economy operator test and assessing whether or not the public authorities acted as a market economy operator would have done in a similar situation. So the question for the court was, is this a public authority not acting as a public authority but acting in a commercial capacity? And thereby it needs to be compared with what a rational market economic operator would have done in that situation. And it was in that context that the judge had recognised that a wide margin of discretion was appropriate, because if we look at page 1193, going back to 1193, Roman 10, it says the law recognises there is a wide spectrum of reasonable reaction to commercial circumstances in the private market. So all of this is geared up to my submission being that this is dealing with a very different situation from that which is before this court, because it involved a local authority acting in a private capacity equivalent to a market economic operator, and the issue was the discretion to be given to a public body acting as a commercial operator would in that situation. The difficulty with this decision is that it wasn't dealing with the grant of aid that is nothing to do with a private decision by a public authority acting in a private capacity. It was dealing, with the application of the CMO test. And the court was not concerned with the justification for aid recognising to be state aid, because it acknowledged that this was not state aid precisely because the CMO principle was met. If we turn back to page 1190, it was recognised that if the CMO test had not been met, then the aid should have been notified to the European Commission and the Council would have been in breach.
Where are you reading from?
Top of paragraph 15, page 1190. It's common ground that the Coventry City Council was a manifestation of the member state. The appellants assert that the Council breached the EU standstill obligation. Left to my own devices, my instinctive reaction is, assuming that the loan constitutes state aid, the action of the City Council resulted in the UK being in breach of the standstill obligation. So whatever this case says about margin of discretion is not in the context of it being recognised to be state aid at all. Now here we've got the government recognising that the subsidy it's given needs to be compatible with the TCA principles. So it is subsidy recognised as a subsidy by this government. Therefore, the margin of discretion shouldn't be applied. But unfortunately, the Divisional Court did apply the margin of discretion based on this case.
So what paragraph was that in the Divisional Court judgment?
240, page 164.
Thank you.
Core bundle. That's notwithstanding that it accepted at paragraph 96, page 125, that the hedge would not have been available on the market and that there was an interest-free loan.
So, sorry, I've got
So my
It's the end
point.
of a long day. We've rushed into Coventry without seeing what you were obviously attacking a target, which I didn't even know what the target was.
With respect, given the late hour, I should have reversed the order of batting. I should have started with the proposition and then shown you the case.
Don't worry. I'm
afraid
we've got there. No.
Been trying to rush through.
No, I know the pressures.
But that does bring me to the end of ground 2.
Very well.
Thank you for your indulgence.
No significant indulgence. Very well. 10:30 tomorrow. And just remind me, because I've lost the bit of paper, that I'll have it back
We're
on my desk.
sitting-
You're going on for another.
12:20 we sit down, hopefully. With
That was some rather
hard stop at
subtle thing
12:30.
about you actually were hoping you could sit down earlier, but you'd have to sit down whatever at 12:20. Was that it?
No, the other way. It's 12:30 is the hard stop.
Yes, I see.
12:20. There's been some intense negotiation over
I
10
can
minutes.
see. It's ultimately a matter for the court. If we want to hear from you, they'll have to lump it. But
Your Lordship can say that in circumstances where
I agree. That's short.
By my learned
You're
friends, if I
proposing.
suggest.
Very well.
I should add, we've covered quite a lot of the ground on ground 3 on the facts already, so I'm hoping I
Yes.
can cut my cloth.
Very well. 10:30 tomorrow. Thank you. Thank you for the short answer.